Hi, have you received a letter from a no-win, no-fee solicitor claiming thousands of pounds from you because you haven't protected your tenant's deposit? Don't worry, you're not alone. And I work with hundreds of landlords and letting agents who find themselves in this situation on a daily basis. The first thing to do is please don't panic. It's unlikely that the solicitors have actually got all of the facts and the claim has any validity to it. Now, what I mean by that is a lot of the times these solicitors firms will literally take the tenant's word for it, not really do much background checking into the validity of the claim, and then just put in this extortionate amount of compensation that they're demanding from you, or they're going to go to court and you're a bad person. So a lot of the times what we find out once I've actually assessed the case is there aren't as many breaches as the solicitors claim, and in certain circumstances there's no breaches at all. So please understand that when you get one of these letters, don't panic, although it's really easy to do that. It's a scary letter. I've read many of them. Come to me and I will do my best to sort it out. Now, I'm going to talk to you about one of the clients I've been working with recently and how easy it is to understand how these solicitors firms are making their money. So this was a very hefty claim, and it was £15,000 was the amount that the solicitors firm was claiming, and that was for 4 tenancies. Now, what I mean by that is each time a tenancy is drawn up, that's a new tenancy. If you then write a renewal, that's a new tenancy. If the tenancy ends and no new contract is written up, one of two things can happen. A contractual periodic, that's a continuation of the fixed term, or a statutory periodic, which in the eyes of the law is a brand new tenancy, although it's technically a continuation. It's confusing, but this is where I think a lot of the solicitors firms also get confused. So what happened in this case is we had 4 properties, 4 tenancy agreements, and the claim was there was a breach for each of these tenancy agreements. So £15,000 is a hefty amount. So first of all, I wanted to look at how much the deposit was, and the deposit was more than the 5 weeks that we would expect to see on an assured short hold tenancy. So that rang some alarm bells for me as well. But then I had a look at the more in-depth elements of it. So all of the tenancies were in the same name. Now they're all for completely different properties, not even in the same street, the same block, nothing. 4 separate tenancies. I'm like, well, one person can't live in all of those properties at once. That's not possible. So I delved a little bit deeper, and actually it turned out that this particular tenant was actually a rent-to-rent operator, and the assured short hold tenancy that he'd signed between the property owner and himself was just actually the wrong document to use. And we see this so many times. I see so many amateur rent-to-rent operators signing ASTs with the property owner thinking that's the right document. It isn't. It really isn't. The legislation doesn't even allow it to be in existence. So I went back to the solicitor's firm and explained this. I quoted the Housing Act of 1988, which explains why these 4 tenancies couldn't actually be assured short hold tenancies, regardless of what was written on them. Even though it said it was an AST, it couldn't be. They argued the toss. I went back with a little bit more evidence from Companies House and things like that, and then additional tenancy agreements from the actual occupants, and finally they backed down. So in this particular situation, the £15,000 that they were originally claiming was actually reduced down to 0. The solicitors firm don't like it when that happens, and we didn't even get a letter to say we're closing the case. I actually had to phone up and speak to the firm, and they just kind of brushed it under the carpet. Oh yeah, well, we're not taking it forward. So please, if you get one of these claims, don't think for a moment that you have to pay the amount that's on that letter. Sometimes, like as in this one, they don't actually have a valid claim. It was just because the tenant had said they got an AST and they'd paid a deposit and it wasn't protected that they immediately thought somebody was going to write them a blank cheque for as much fees as they could get and pay this tenant some compensation that they weren't even legally owed. So please, if you are a property owner working with a rent-to-rent operator, make sure they do not have an assured short hold tenancy signed between yourself and them. It can't be. Legally, it can't be, regardless of what you've signed. And also be aware that they might try this trick, although it won't actually stand up in court. It certainly won't stand up legally. So please, if you've had one of these no-win, no-fee solicitors letters claiming that you owe thousands for non-protection of deposit, get in touch with me. I will assess your claim. I will tell you the validity. If you have breached the legislation, I'm not getting you off, but I'm going to do my best to reduce the amount that you pay within the requirements of the legislation. So please do get in touch. Don't panic. I will sort it out.